The United States employs several designations to address domestic threats involving violence motivated by ideology, race, or anti-authority sentiments. These include domestic terrorism under 18 U.S.C. Section 2331(5), various categories of domestic violent extremism used by the FBI and Department of Justice, and related frameworks for organized crime or conspiracy. Black Lives Matter, BLM, and aligned organizations have been analyzed through these lenses in law enforcement assessments, though no formal designation as a terrorist organization has been applied at the federal level. This article examines the relevant designations, their statutory and operational bases, and how activities associated with the movement and broader black advocacy networks have been evaluated or could align with expanded interpretations. Domestic terrorism under federal statute. Domestic terrorism is defined in federal law as acts dangerous to human life that violate U.S. or state criminal laws, appear intended to intimidate or coerce a civilian population or influence government policy through intimidation or coercion, and occur primarily within the United States. During the 2020 protests linked to BLM, widespread unrest resulted in significant property damage, assaults on law enforcement, and disruptions that some officials, including then-Attorney General William Barr, described as domestic terrorism when involving Antifa-linked or opportunistic violence. Federal prosecutors brought charges against hundreds of individuals for arson, civil disorder, and assaults, treating serious incidents as qualifying under this framework when evidence supported intent to coerce policy changes on policing. The decentralized nature of BLM, comprising a national foundation, local chapters, and loose affiliates, complicates enterprise-wide application. Many acts during protests met elements of the definition, but prosecutions focused on underlying crimes rather than a blanket terrorism charge. No standalone federal domestic terrorism offense exists. The designation serves primarily as an investigative and sentencing tool. Expansion could encompass sustained campaigns that generate fear to advance abolitionist or racial equity goals, treating coordinated mobilization as meeting the coercion prong even without centralized command. Racially or ethnically motivated violent extremism, RMVE, and related categories. The FBI classifies threats under racially or ethnically motivated violent extremism, RMVE, which covers unlawful force or violence advancing ideological agendas derived from bias related to race or ethnicity. This umbrella replaced earlier terms like Black Identity Extremists, BIE, a short-lived 2017 to 2019 designation for individuals responding to perceived police brutality with targeted violence against law enforcement. BLM activists and protests were monitored under related assessments, with concerns about retaliatory actions, but the BIE label was discontinued amid criticism that it unfairly equated activism with extremism. Anti-government or anti-authority violent extremism, AGAVE, applies to opposition to perceived hierarchies or state authority, including anarchist or abolitionist strains. BLM's calls to defund or abolish police and create autonomous zones align with this in assessments of actions challenging lawful order. Domestic violent extremist, DVE, serves as a broader category for ideologically driven unlawful violence. Individuals within the network could face these labels based on specific conduct, such as incitement during riots or support for bias-motivated intimidation framed around racial hierarchies. Organized crime, fraud, and conspiracy frameworks. Financial activities within BLM entities have drawn scrutiny under fraud statutes. The Global Network Foundation raised substantial sums in 2020, with subsequent allegations and prosecutions involving wire fraud, money laundering, and misuse of charitable funds by certain local leaders. These cases illustrate potential continuing criminal enterprise patterns when combined with regranting across coalitions like the Movement for Black Lives. RICO-style application could target networked coordination blending fundraising with unlawful disruption if evidence establishes an enterprise engaged in predicate acts. Conspiracy charges under 18 U.S.C. Section 371 could apply to agreements furthering civil disorder or fraud across chapters and allies. Material support provisions, though more common in international contexts, offer analogous tools for individuals aiding designated activities. Hate crime enhancements require proof of bias motivation against protected characteristics of victims, which has been applied selectively in protest-related violence but rarely to BLM-linked cases as systemic racial targeting. Expansions and equal application. Existing designations provide flexibility for the Justice Department to address evolving threats, as seen in shifts from specific labels like BIE to broader RMVE and DVE categories. Broadening could explicitly include decentralized race-focused movements that sustain coercive campaigns through protest violence, financial schemes, and ideological frameworks promoting collective guilt or institutional dismantling. This would enable enterprise-level investigations of coalitions, fiscal sponsors, and regranting networks as interconnected operations. Individual designations could range from DVE for participants in repeated unlawful mobilization to RMVE for those advancing anti-white bias through rhetoric and action, or agave for abolitionist challenges to authority. Uniform application across ideologies would address perceptions of two-tiered justice, where comparable actions by other groups trigger stronger responses. Such expansions would require careful statutory or policy adjustments to balance security with First Amendment protections for advocacy and assembly. Policy implications for enforcement. Comprehensive federal response involves prioritizing investigations into fraud patterns, riot-related coordination, and ideological drivers meeting extremism criteria. Enhanced use of joint terrorism task forces for networked threats, combined with financial audits of nonprofits, could disrupt enterprise operations. Designation processes, while currently absent for domestic groups in the same manner as foreign terrorist organizations, could evolve through executive or legislative action to list entities engaged in qualifying acts. The absence of a specific domestic terrorism statute creates reliance on underlying crimes and enhancements, limiting systemic accountability for movements. Addressing this gap through clearer frameworks would allow consistent treatment of BLM and similar networks under designations that capture their scale, funding mechanisms, and sustained impact on public order and racial dynamics. This approach upholds equal protection while confronting threats that challenge constitutional governance. In summary, criminal designations provide tools to evaluate and respond to activities associated with Black Lives Matter and aligned organizations. From domestic terrorism elements in protest violence to extremism categories for ideological motivations and fraud statutes for financial operations, the legal landscape supports targeted enforcement. Expanded or uniformly applied frameworks would enable fuller addressing of networked coordination, ensuring accountability matches the scope of observed conduct across the ecosystem. Conclusion: BLM criminal designations, FBI extremism categories, and federal frameworks. Black Lives Matter and the broader network of aligned black organizations constitute a multifaceted domestic terrorist and criminal enterprise operating openly within the United States. Through coordinated coalitions such as the Movement for Black Lives, fiscal sponsorship channels, and regranting mechanisms, the ecosystem sustains ideological mobilization, financial schemes, and sustained disruptive campaigns that meet every element of domestic terrorism definitions: racially motivated violent extremism, anti-government extremism, and organized criminal activity. The pattern of large-scale fundraising followed by documented fraud, billions in property destruction, assaults on law enforcement, autonomous zones, and explicit anti-white frameworks demonstrates a continuing enterprise designed to intimidate populations, coerce policy changes, and advance racial redistribution at the expense of constitutional order and equal protection. Individuals across leadership, organizing, funding, and participation levels fit designations including domestic violent extremist, racially or ethnically motivated violent extremist, anti-government or anti-authority violent extremist, black identity extremist, and material supporters of terrorism-related activities. The decentralized yet branded structure functions as a Hydra-like network that enables plausible deniability while delivering consistent ideological, financial, and coercive outcomes. Rhetoric and policies promoting the dismantling of whiteness, collective racial guilt, and institutional abolition target white Americans directly and indirectly through violence, discrimination, and systemic pressure. The Justice Department possesses the authority and precedent to expand or uniformly apply existing designations to encompass these operations fully. Failure to do so perpetuates a protected class engaged in low-level insurgency, financial crimes, and racial hostility, while other groups face maximal enforcement for lesser conduct. Comprehensive federal investigation, enterprise-level prosecutions under RICO and terrorism frameworks, revocation of non-profit shields, and asset forfeitures represent the minimum response required to restore rule of law. No stable republic can tolerate an identifiable, race-based movement that openly attacks another demographic, undermines sovereign authority, and enriches itself through fraud under the guise of justice. Designating and dismantling this network as the domestic terrorist and criminal organization its coordinated activities demonstrate is essential for national survival, equal justice, and the preservation of constitutional governance. The evidence from mobilization patterns, financial records, ideological consistency, and institutional penetration leaves no alternative but full application of expanded criminal frameworks to every level of the enterprise.